40 of 2022.
Review petition has been filed for reviewing the copy of the order dated 2nd of May 22, cost and WPS number 736 of 2010. Which I just directly brief facts and what has happened
No,
subsequently.
you just give me the ground.
Your Addition, the only ground that I have is that subsequently petitioner number 2 of this WPS 736 referred an LP where the Honorable Division mentioned, considering the fact that he is still continuing in service, has Your Lordship granted him the relief that he has paid for in the requisition, which I just provided a copy of.
So,
And in this case also, Your Lordship, the petitioner is still working on the same post of basic health worker since 2010, which is still continuing in service and is about to attain
this
the.
judgment was subject matter of LPA.
Yes.
Now, where is the question of review?
Your Lordship, only one of the petitioners preferred an LPA. So this was subsequent to this review petition.
Now it has merged with the final judgment passed by the appellate.
Your Lordship, only kindly come to para 5 and 6 of that LPA order.
No, we are not going to take care of the LPA order. You tell me what is the ground for review. Any error apparent on the face of the record?
Your Lordship, the observation that was made in para 41 and 45 onwards, that since there was no fresh termination of a reappointment or termination order of these petitioners, therefore they were not considered in the light of Arun Kumar Rao case.
No. These are all on merits. They are not. Since review number 40 of 2022. This civil review application has been filed by petitioner number 4 of WPS number 736 of 2010. The learned counsel for the appellant has submitted that LPA number 254 of 2022 has been filed by petitioner number 2 of the petitioner, by petitioner number 2, and the same has been allowed by judgment dated 5th of January 2023. The learned counsel submits that now the petition number 4 he submits that prior to disposal of the LPA, the petition number 4 has filed the present civil review petition, and similar relief be granted to the petitioner as granted in LPA number 254 of 2022. Correct?
Yes.
After hearing the counsel for the petitioner, this court is of the view that the subsequent judgment which has been passed in LPA number 254 of 2022 in connection with the co-petitioner, co-lead petitioner of the present review petitioner whereby whereby the LPA filed by appellant petitioner number 2 has been allowed is not a ground to seek review of the order passed by this court. Accordingly, the civil review petition is hereby dismissed.
From supplementary list for hearing on order 41/11 item 77, second appeal 41 of 2026.
Appellant has challenged the order passed by the first appellate court, whereby his first appeal has been dismissed on the ground of limitation being barred by 600 The appellant
It was barred by
600 for whom we need to verify the 600.
okay.
600. It was barred by 600. But the appellant for the lordship was originally defendant number 6 before the trial. And he is the subsequent purchaser of the land in the year 2011.
Subsequent purchase means during the pendency of the suit.
No, he was the purchaser. His vendor purchased the land from the recorded tenants.
You see, that is a separate thing. You tell us what is there on limitation. Because the appeal has been dismissed on limitation.
I came to know about the order passed in the suit only when there was a paper publication when the execution case was instituted. I was directed to appear on 18/12/2022. I appeared, but I made a chart of the chronological list of events and the conduct of the appendix. I may be permitted to please. Just to demonstrate the bona fide of the appendix, the chain of events and the conduct of the appendix respectively. I was directed to appear on 18/12/2024
Before whom?
in the execution proceeding as a judgment letter. I appeared on the very same day. Thereafter, I obtained the certified copy of the trial court's judgment on 21st/12/2024. Thereafter, however, the learned lower courts went into the winter vacations, and on 15/1/2025, I filed the first appeal. So the moment I came to know about the order passed by the learned trial court and the pendency of the execution case, I acted upon vigilantly manner. To demonstrate this, I have made this summary, which is at page 2. I have the certified copy of the order sheet as well. So please just. But this aspect of the matter has not been taken care by the learned first appellate. Permits me to place few judgments as well.
You are filing this case in the capacity of what is your description? What was the description of the buyer in the deed? Lies and allegations. Oh. What was the description of the buyer?
I purchased it through the vendor's vendor. Plaintiff filed the case for declaration of title and cancellation of the same.
your name in the deed is Pramod Kumar,
My-
but not Pramod Lal.
No, and that is not my name. Pramod Lal is not my name. My name is Pramod Kumar.
The defendant was? Defendant was Pramod Lal.
Pramod Lal.
And you have filed the case in the name of Pramod Kumar.
I have not filed the case. I have
No,
not.
the appeal.
Appeal is in my. Pramod Kumar.
You see, if there is any dispute regarding the identity, and if the suit has been filed in the name of wrong person, then you have a remedy before the executing court. Because even if the appeal is entertained, appeal is allowed, and everything is done, it will fall back on this only, that the description of the defendant is not correct. So the actual person has not been made party. So what is the
Two
consequence?
things. As a matter of fact, execution proceeding has already been culminated, my lord, and the petition has been taken away from the applicant.
You had a remedy.
And second thing, my
No,
lord.
no, we do not know. You see, the point is that if you were on the spot and you were to be evicted, although the case was filed in the name of wrong person, then why didn't you file your objection before the executing court?
As a matter of fact, the address portion in the sale is same as contained in the claim.
Maybe anybody in possession can object.
And my lord, the cancellation, the prayer for cancellation of the sale deed is in my name. The sale deed number is 2991.
Maybe it is in your name, but you are not a party in the suit.
The courts below did
You are
not
not a
pay
party in
heed
the
to
suit.
this fact, my lord, and they
You
have
don't bother about
proceeded.
it. You are not a party in the suit. The decree is not against you.
But
You should have taken steps. You see, the law provides a remedy, but you have missed to exercise your right.
That has been done already.
So we
As
do
per
not know.
my instruction,
We just do not know.
as per my instruction, my lord. However, my lord, I would take this honorable court.
The appeal itself was not maintainable,
My lord, I would take this.
and in your name, because you have not filed the appeal in the name of the decree against whom the decree has been passed.
But everything.
This appeal, how this appeal has, how the just a moment, how the defects have been ignored in this case?
My lord, the thing is.
How the defect? The office has not pointed out this defect.
Promote.
They should have.
This defect has.
But once you are not a party in the suit, how your second appeal is maintained?
My lord, if I am not a
No.
party, but there is a declaration that my sale is null and void. My valuable rights.
That is not binding on you since you are not a party in the suit. यहाँ पे तो spelling mistake का भी defect निकालते हैं. Spelling mistake का भी.
वही.
पिताजी के नाम का भी spelling mistake होता है तो defect निकालते हैं. आप पार्टी नहीं है सूट में, आपका second appeal कैसे entertain करेंगे हम?
But my rights have been cut and taken away totally.
First, I am on the decree. Just tell me. आप ट्राई कोर्ट का डिग्री लगाए होंगे ना? Yes.
Pramod Lal. It is also Pramod Lal. I was running a study hall of my memo saying Pramod Lal.
यहाँ पे ये ऑब्जेक्शन था regarding your correct name. We have just ignored it for the present. अब आप हमको बताइए.
But my
The defect is it appears that page number 10 of the corrected CC of the judgment in civil appeal is not readable. Hence, it may be sent down to the court below for necessary correction. After receipt of the corrected CC of the impugned order, learned counsel may verify and correct as same in the memo.
No, it is in respect of page 10 in the trial court judgment.
This appeal,
That
you
is.
see how do we entertain a appeal on behalf of a person who is not a party in the proceeding? Show me some law on this.
I will have to research on that. That is.
What research? Go and do your research.
My lord, my only humble submission in this regard would be that maybe my name is written as Pramod Lal instead of Pramod Kumar, but the relief which has been sought by the plaintiff directly
Where is the
pertains
tripod decree? Here it is.
in the last page, running page 31. Relief C may be seen.
Pramod Lal.
And relief C pertains to my city.
Maybe it is pertaining to you, but you are not a party.
And it
to
has
this.
been executed now. It has been
You have not taken right steps at the right time.
But that cannot be, the appellant may not be permitted to suffer for that matter.
And it is not that, it is wife of
Wife,
Pramod Lal, wife of Madhu Lal.
वो शुरू से हुआ है सेल डीड की वजह से. They have
We do not
captured
know
the name.
किसकी वजह से.
But सेल डीड में प्रमोद कुमार है. मतलब that may be one of the measure to dilate the issuance of notice.
We will not accept this.
But what will happen to the rights? The property has gone.
आप हमसे सवाल पूछना बंद करिए. The law provides a lot of remedy to the litigant. You have not taken right step at the right
I am
time.
aware of it.
You have not taken any step at the right time. You should have objected at the stage of decree. जब आपको हटाने आया होगा तो physically आपको हटाया होगा ना?
Vacant land.
Vacant land.
That's not a mystery. It's a vacant land. I had the remedy under order 21.02.2026. I am aware of it. But यहाँ तो
No,
कैसे हो?
this appeal is not maintainable at your instance. In this name, no, we will not permit this appeal.
What is my fault? If the case is instituted against with a wrong name, challenging my salary, what is my fault? I am not the plaintiff, man.
The judgment is not binding on you.
Madam, may I observe this?
Why should I observe it?
But what
You do not know the law.
I understand.
If a case is filed with wrong description of party,
that has to be looked into by the
male female का भी फर्क है.
पति कर दे रहे हैं.
Yes.
It indicates that he is a woman. वो indication आ रहा है. तो ये
जरा-
observation सिर्फ हो जाएगी.
नहीं, this defect cannot be ignored. We will not be एक कॉमा फुल स्टॉप के लिए भी ये लोग डिफेक्ट लगाते हैं. आई डू नॉट नो आपका ये डिफेक्ट आपके केस में क्यों नहीं.
नहीं लगा, ये defect नहीं लगा. सिर्फ पेस्टेंट की. My property has gone. That is my right.
Second appeal number 5, second appeal number 41 of 2026. The learned counsel for the appellant has submitted that original suit number.
If I am permitted, जजमेंट शुरू हो गया तो बोलना नहीं ठीक. My property has been taken up maliciously, and because I am not named as a party in that list, my salary which speaks the correct name, which describes the correct name, that property has been taken by the plaintiff.
Your sale deed is giving the correct name.
The
Which is correct? Your sale deed is correct or your name is correct?
salary is correct, and my
Sale deed
name
में
is.
वाइफ ऑफ बता रहा है और लाल बता रहा है.
सैलरी में नहीं है.
वहाँ फादर में भी माधो लाल.
हाँ,
the name of the applicant is
प्लेंट
Kumar.
प्लेंट में वो सब गड़बड़ किए हैं विद द इंटेंशन टू हैव ए बाला डिग्री।
सेल डीड में प्रमोद कुमार
जी
पति माधुलाल।
पिता को पति हो गया है, लेकिन यहाँ देखा जाए तो वाइफ ऑफ लिख देते हैं।
सर आप हमको इतना बता दीजिए, जो डिग्री है वो तो जो
जी
जजमेंट लेटर होगा उसके अगेंस्ट में ऑपरेट करेगा ना।
बस उतना लिख दिया ताकि हम
उतना
रेस्टिट्यूशन
हम
ऑफ
क्या
पोजेशन,
बोलेंगे?
तो रेस्टिट्यूशन ऑफ पोजेशन के लिए हम केस करेंगे।
वो आप क्या करेंगे आप जानिए, बट द अपील इज नॉट मेंटेनेबल इन द नेम इट हैज बीन फाइल्ड।
यस
It is not maintainable because such and such a person is not a party. It's not a party.
I bow down, but the thing is, in the name of that incorrect name, property of
सर आप एग्जीक्यूशन में आप क्या कर रहे थे?
Well, in the execution case we filed.
No, you did not file anything in the execution.
I appeared one. I appeared.
आपका फिजिकल पोजेशन जब ये आप फाइल किए कि आपके नाम से डिग्री नहीं है,
नहीं ये नहीं किए हैं।
फिर क्या किए?
But my lord is a justice of peace also. My lord will see the law.
Sir,
for
I am
doing
seeing the
justice.
law. I am seeing the law.
I'm not reminding. I'm just making my submissions, my lord. My lord, it may suit to your lordship. May
सर
not
ये
suit.
डिग्री हम कैसे सेकेंड अपील में ये ऑफिस कैसे नहीं पॉइंट, आपको यकीन नहीं होगा अगर ओ की जगह ए लिखा जाता है ना तो भी यहाँ पे डिफेक्ट होता है एंड उसको डिफेक्ट क्योर करना पड़ता है।
अब
तो
कैसे वहाँ पे हो गया?
ये आपका ऑफिस ने नहीं डिफेक्ट और पॉइंट के आंख बंद कर दिया।
मेरा humble submission है कि the limitation part will be seen and
नहीं,
it
I
will be
will not.
remanded.
No.
Then who is at mistake? Who is the deliberate committing the deliberate mistake?
Deliberate
Intentionally.
mistake is आपने समय पर अपना एग्जीक्यूटिव कोर्ट में अपना पिटीशन नहीं फाइल किया, saying that this decree is not against me and I have a registered sale deed in my name and therefore this decree is not an
I
executive.
bow down, my lord. Mistake of a lawyer should not be thrust upon the party, my lord, to bear the brunt.
सर
It's a
आपका ये अपील
Mistake of the lawyer, my lord, he should have
आपका
given.
ये अपील रजिस्ट्री से कैसे क्लियर हुआ ये तो हमको रजिस्ट्री से पूछना पड़ेगा।
हाँ देख लिया
पूछना
जाए,
पड़ेगा।
देख लिया जाए।
लेकिन this is not maintainable on the face of it. A judgment cannot be challenged by a person having a different name.
Obviously, but I was also
You are not
thinking.
a party.
I was also thinking that if a
सर
letter
बहुत
is
सिंपल सा बात है।
जी
Your
हमको रास्ता दिखा दीजिए।
रास्ता हम तो बस इतना ही बताएंगे कि भाई आपका ये जो डिग्री तो प्रमोद कुमार के नाम से है ही नहीं,
है नहीं।
इतना ही बोलेंगे। therefore this appeal is not maintainable at the instance of प्रमोद कुमार। क्या बोलेंगे हम? इसके अलावा तो कुछ नहीं बोल पाएंगे।
I cannot go anywhere. If I go to the trial court or the execution court, at the most I can go to the execution court. They will say कि जाइए वहाँ ट्रायल कोर्ट से करेक्शन कराइए।
Correct?
और ट्रायल कोर्ट कहेगा कि I am functus officio, हम तो ऑर्डर पास कर।
तो ट्रायल कोर्ट के पास आपके पास रेमेडी नहीं है,
रेमेडी है।
हाँ तो फिर जाइए।
सेक्शन 144 सी 144 आईपीसी में प्रोविजन
आपको
है।
तो हम प्रोविजन आईपीसी
हाँ
आईपीसी क्यों
है। रेस्टोरेशन ऑफ पोजेशन सीपीसी में
तो है, तो you have a remedy, no? How this appeal is maintainable?
My lord, I have filed this case because I have given the correct name. My lord, may record my submission that the person having the title over the scheduled property has come before this court. Scheduled property पे हम करेक्शन करा लेंगे।
क्या करेक्शन कराने?
152 में हम करेक्शन कराएंगे।
Degree.
Section 152.
Who are you? You are nobody. You are not a party.
If my lord, my property is taken away, there will
If
be,
your person, if your
there will
property
be a
is,
fraud
if
committed
you
on the
are,
court.
if your property is taken away and you have not been made party in the proceeding,
जी,
that is not binding on you.
तो फिर हमको रेस्टोरेशन
तो
करा।
हम यहाँ पर कोई क्लास लगा दें क्या? आपको क्या करना होगा?
मतलब
This
at
is
least-
not none of my job,
at
sir.
least-
जहाँ पर आपको जो मन होता है आप लोग फाइल
At
कर
least
देते हैं.
court can discuss this, my lord.
No, I will not
It
discuss it.
depends upon the nature of case, therefore, my lord, in every case, my lord applies, my lord, judicial discretion, based on the judicial conscience of the honorable court, on the long experience and knowledge, my lord will consider. Where I will go, a person having a property.
सर आपके पास थोड़ा सा रिसर्च करिए, अपने
जी।
सीनियर लोग को बोलिए, आपके पास बहुत सारा उपाय हैं, लेकिन ये अपील हम नहीं सुनी, ये अपील नहीं मिलती at your instance.
तो हम तो लाल है नहीं, तो लाल के नाम से हम फाइल नहीं कर सकते।
कर ली सर, और आपने किया भी नहीं।
हम कर
Right,
नहीं
नहीं
सकते
किया।
हैं। If I am
और
RN
ये
Sahai,
criminal case थोड़ी है
I
कि
cannot
alias
file a
में
case
जवाब
in the name of RN Singh. नहीं कर सकते। If my property is taken
Secretary
away,
number 14 of 2026.
बहुत heavy हो जाएगा हमारे ऊपर।
सर
The
आपके
fraud
पास
will
बहुत
prevail
सारा
against the
है।
genuine person.
सर आपके ऊपर कुछ हेवी नहीं होगा, आप अपना होमवर्क नहीं कर रहे हैं।
अभी तो आप
This
बोल रही
appeal
हैं
has
तो हम
been
मान
filed-
लेते हैं।
नहीं अब हो क्या? This appeal has been filed by Pramod Kumar, aged 62 years, son of Madhu Lal, against the judgment dated 13/8/2025, passed in civil appeal number 6 of 2025 by the learned Judicial Commissioner Ranchi, affirming the judgment dated 31/1/2023 within bracket decree dated 10/2/2023, passed by learned civil judge within bracket senior division dash Roman 7 Ranchi, entitled suit number 567 of 2016, whereby the title suit was allowed ex parte. The learned counsel has submitted that the appeal filed by the appellant has been dismissed on the point of limitation. During the course of hearing, the learned counsel for the appellant has submitted that the decree, that the perusal of the decree revealed that the case was filed against 6 defendants and one of the defendant was Pramod Lal, wife of Sri Madhu Lal, and the sale deed number 29951/25590 of the year 2011 dated 29/11/2011 was under challenge. He submits that by ex parte judgment, the suit has been decreed. The learned counsel submits that the sale deed involved in the case was that of the appellant, that is Pramod Kumar, son of Madhu Lal. He has also submitted that sale deed was exhibited before the learned court and in the same, the name of purchaser was Pramod Kumar, wife of Madhu Lal. The learned counsel submits that that was a typographical mistake in as much as the sale deed reveals that the sale deed was in the name of Pramod Kumar and father's name was Madhur Lal. The learned counsel has submitted that the suit itself was filed giving wrong name which did not match with the sale deed, and the suit has been decreed. He has submitted that
That is
since
purpose.
the suit was in the name of wrong person, that is Madhur Lal and that is Pramod Kumar and not Pramod Lal and not Pramod Kumar. And as soon as the appellant came to know that the suit has been decreed, he has filed the appeal before the learned first appellate court, and ultimately the first appellate court, though has not taken note with respect to mismatch in the name, but has dismissed the appeal on the ground of limitation.
Not correct name, no address.
Address
किलबर्न करने में 1000 से ज्यादा है। ना मेरे अपार्टमेंट का नाम है, ना फ्लैट नंबर है। कैसे हमको मिलेगा? और लिख के चला आया कि साहब नहीं रिसीव हुआ। टाइम नहीं है, उसका गवाही नहीं हुआ जो प्रोसेस सर्वर था।
आपका यही एड्रेस सेल डीड में,
जी
आपके सेल डीड में भी वही
जी
एड्रेस, जो एड्रेस दिए हैं सेल डीड में उसी नाम से केस होगा।
I have come to seek justice, my Lord will decide where justice lies. एक बार बुलाकर पूछ तो लिया जाता, नोटिस करके how he has instituted a case against a wrong person and taken possession of the property belonging to the person who was not a party to the list.
The learned counsel has also submitted that since the case itself was instituted against Pramod Lal and not against Pramod Kumar, there was no occasion for the appellant to contest the suit. Okay?
And I also I had no
He has also
notice.
submitted that
I had no notice. My
The-
apartment name is not given, flat number is not given. You should have inquired
Notice-
before remaining. I may have shifted to somewhere else.
the notice was also not served, was not personally served upon the appellant. And the appeal has been dismissed, which was barred by limitation of 685 days. The learned counsel has submitted that if opportunity is granted to the appellant if opportunity is granted to the parties, then the description of party in the suit can itself be changed, and the appellant may have the opportunity to contest the suit on merits. Besides that, in that case, the appellant would not dispute his identity. This appeal is admitted for final hearing on the following substantial question of law: whether the learned first appellate court was justified in refusing to condone the delay in filing the appeal under the facts and circumstances of the present case. Under the peculiar facts of the present case.
This word actually suits to these facts of this case.
Let notice be issued to the respondents to the concerned police station for which the
1 to
request is
7.
filed. All the respondents
Madam.
for which request be filed within a period of 1 week from today.
Okay.
Records have already been received. Appellate court का record नहीं आया. इसमें appellate court का record नहीं आया. I was looking.
मंगवा लिया जाना.
That the records of the trial court be called.
And the appellate.
नहीं appellate court. Record तो original court का आया ही नहीं.
जी.
ट्रायल कोर्ट का सारा रिकॉर्ड बनाया.
जी. पर एक और हम सबमिशन है, वो जो ओवरलैपिंग हो गया है पेज 10 का, उसको भी वो करके भेजी नहीं.
कहाँ से करके भेजी? बाद में कभी
ऑब्लेजमेंट.
फिर आपको बाद में आइडेंटिटी डिस्प्यूट नहीं करना है.
कभी नहीं.
इतना ही आपको बस एक मौका दे देंगे कि आपका पार्टी पोजीशन चेंज होगा एंड द ट्रायल कोर्ट विल डिसाइड दैट. इसके बियॉन्ड नहीं करना है.
नहीं, उससे नहीं जाना चाहिए.
स्पेशल मैसेंजर फर्स्ट अमाउंट
कर दें.
26
तो रामसी का ही है, हम तुरंत कर दें.
26 बोल रहे.
ऑब्लेजमेंट.
From date is for hearing on order 41/11 item 29, second appeal 224 of 2020.
Actually, this is the second appeal raising out of a partition suit. And both the courts have concurrently held against the appellants. The suit has been decreed. The substantial question of law urged this time consideration would be that despite the revenue court's judgment passed under section 87 of the Chota Tenancy Act, it was filed by way of an exhibit B. Which both the learned courts have not considered the legal effect of that decree because a simple suit for partition would not be maintainable. Because the decree it is in nature of a decree, the section 87, because the appeal also lies to the High Court, up to High Court. So even though the person may not be a party, the plaintiff was not a party in that section 87, but it was a judgment passed by a revenue court exercising jurisdiction. So a simple suit for partition without.
That is just a petition for rectification of record of rights.
Leadership, section 87, there is the suit has to be entertained by the civil court for correction of the revenue records. Now, as far as that is concerned, then there is a section 258 also, which says that
For rectification of record of rights.
yes,
if a suit
leadership,
is
but there is a
dismissed-
section.
If a suit is dismissed
Yes.
on account of rectification of record of rights by the revenue authority, does this will debar the parties to go for petition?
Leadership has happened conversely. The section 87 application was allowed in my favor. The records of right were corrected. My name was entered in the record of rights. Thereafter, the other party was not a party. The other person who is the plaintiff in the incident partition suit, despite my bringing on record, the judgment passed under section 87, he has chosen not to assail that, and he persisted with a simple suit for partition. Because if the record of rights, because that has a legal consequence, Your Lordships. Section 84, even despite section 84, once there is an adjudication by a court, because the court's order cannot be invalidated by the litigant himself. He has to approach the court, seek an appropriate decree. Otherwise, Your Lordship, section 34 also says that if a person is entitled to a legal character, he must seek a declaration of that effect. Now, Your Lordships, because what has happened is, the issue is that Amodin Kumari, who claimed herself to be the son of one Harpu, and we say Harpu is not a person, he was a fictitious person. He was not hailing from the family. Lord, the ladyship may kindly see the genealogy for a moment, which is reproduced at page 5 of 28 of the appellate court decision. I'm sorry, the original court decision at page 5. The genealogy is there at page 5. Ladyship's got that. This says that Bharat Kumar had three sons, Gondu, Sahib Ram, and Sukla. And thereafter he had, as per the plaintiff, one son, Harpu, and through him Amodi Kumarin, who is the plaintiff, original plaintiff. She died, her heirs are there. And she instituted a suit. We say that we are Radha Kumari, the daughter of Gondu Kumar, and the suit lands in view of the section 87 decree. It is exclusively entered in my name. So a simpliciter suit, because in addition Paritosh Mighty case 87.
You are the plaintiff, right?
I am the defendant. I am one of the defendant. I am one of the defendant. I am defendant number 8, defendant number 6.
6, one of the defendants.
One of the defendant.
Jaidev Kumar.
Jaidev Kumar.
Where is your name over here?
Radha Kumarin,
Jaidev Kumar,
yes,
son of Gaur Kumar.
son of Gaur Kumar. And
You are
Gaur
defendant
Kumar,
number 2.
Gaur Kumar was the original defendant number 2.
So you are defendant number 2. Why have you written defendant number 6?
Actually, it was substituted here of defendant number 2. Yes.
Yes, you were defendant number 2 originally.
It should have been also. It should have been substituted. I'm just checking the degree for a moment. I was substituted Nakul Polar W. Because war was arrived when the original court decree was prepared, and thereafter in civil appeal,
Where do I get his name? The decree?
in the trial court decree, ladyship,
Yes. Where is it?
yes, my father name was there, Gaur Kumar,
Where is it?
Gaur Kumar, at
Gaur Kumar.
serial number 2,
Serial number 2.
defendant,
Defendant number 2.
and thereafter he died.
You are not defendant number 6. You
No,
are
no,
defendant number 6.
I'm sorry.
Yes.
I was. I'm appellant number 6 in before the first appellate. So ladyship, my first submission for ladyship kind consideration was to submission for kind consideration is that a simplicitous suit for partition is not maintainable because the consequences of such an order has not only a because ladyship is well aware that section 87 subsection 1 clause double E was inserted by way of 1924 amendment and the Chotanagpur Tenancy Act, and all questions relating to title was to be decided by the revenue court also. So the issue as regard the title, there was an adjudication, even if not, I'm not res judicata, I'm not even for a moment. I'm saying that the validity of a decree had to be challenged. This is what I'm saying. My submission is.
When you say you are not saying about res judicata.
No,
it's
I'm
the
not
same
saying
thing
about
you
res
are-
judicata.
This
I'm
is
not
what you are saying,
No.
that it has to be challenged, otherwise it
No,
will
I'm
be
saying
binding.
this, that a mere declaration ought to have been sought because section 34 says that of the 34 of the specific relief act says that a person is entitled to a legal character because there is a cloud upon his title upon the subject matter. So ladyship, because Paritosh mighty full bench judgment ladyship is aware of in 87 full bench judgment of this honorable court, it has held that despite the bar of section 258 which says that no suit challenging section 87 order passed by revenue court is maintainable. Thereafter, reading the section 87 of the CNT and also section 258 of the Chotanagpur Tenancy Act, the honorable full bench came to a decision that since the civil court's jurisdiction was neither impliedly nor expressly excluded, so a suit for declaration of right title interest would be maintained. So as a consequence of that law, ladyship, if a suit for declaration of right title interest only is maintainable, then if there is a judgment and order passed under section 87, then a simplicitous suit for partition is not maintainable. This is my submission for ladyship kind consideration. And she has also sought an injunction in a permanent injunction without actually obtaining a legal character, a simplicitous suit for injunction against a party who is actually having a decree, a judgment in the favor by a revenue court though, but that order cannot be invalidated lordships by the own assumptions or arrogation of the consideration by the said party. He cannot say that he has acquired the status and he can say
Your written statement has been discussed in paragraph number 3.
paragraph 3 of the trial court.
Right.
Trial. That the defendant 1 to 5 and 8 have appeared and filed two statements alleging the suit is not maintainable. And so manipulated by the plaintiff in manner Bondhu Kumar died leaving behind one daughter namely Radha Kumari and one son Harku, but in reality is that Bondhu Kumar had no son. And Bondhu died leaving behind his daughter Radhi Kumari as his sole legal heir and successor. So the plaintiff falsely inserting the name of Harku Kumar as son. So also according to the land situated in Mauza, Bhaura, number 112 in CS Khata number 11, originally belonged to and the suit recorded in CS record of right in the name of Bondhu Kumar and Sahib Ram Kumar, but there has been a partition between Bondhu and Sahib Ram into the lands in the same plot of Khata 11, including the plot numbers 213, 389 and 420. And his schedule A land was allotted to Bondhu Kumar, and accordingly in the remarks column CS record of right, the land in whose three plots described in schedule A of the plate as well as some plots were shown in possession of Bondhu Kumar and some was along with other land continued in possession till his death. This further affairs with Bondhu Kumar died leaving behind his only daughter namely Radhi Kumari, who inherited schedule A land and continued to possess the same as sole exclusive owner till her death, and Radhi Kumar died leaving behind four sons, Bhola Kumar, Kamal Kumar, Gaur Kumar, Babul Kumar. Accordingly, each four sons inherited 1/4 share in schedule A, and after the death of so and so daughter.
So therefore, the family being joined and all these things are
We are saying that
expected.
ladyship, we are saying that since He's a stranger to that family, and there's a legal effect of that decree, the legal consequence.
So that is not your case, that she says the plaintiff is a stranger to the family. That's not.
No, we have said so. Kindly see my, we say, kindly see para 3, line, 6th line.
Yes.
It is, geological table in schedule B has been manipulated by the plaintiff in a manner to show Bondhu Kumar died leaving behind one daughter, namely Radhi Kumari, and one son, Harku Kumar, but in reality is that Bondhu Kumar had no son, and Bondhu Kumar died leaving his daughter Radhi Kumari as his sole heir and successor. So the legal effect of that order has the effect of actually treating me as the rightful owner, as the heir. So without challenging that, his remedy would be ladyship, despite the interference with the judgment and decree passed by the learned court. He can go and seek a declaration. But without seeking a declaration, he cannot come before this court and ask for an annulment of a in a sub silentio manner, because the thing which has never been prayed for cannot be granted, and despite and without challenging that, he cannot maintain a civil suit for partition. So a legal declaration of a legal character to that effect ought to have been taken in view of section 34 of the specific relief act. And she has taken money in a land acquisition proceeding as the daughter of Bondhu Kumar. Here she is saying that she is the granddaughter of Bondhu Kumar through her. So there is duplicity also as far that aspect is concerned. But that will go into the realm of facts of the case, which ladyship may not be required to go into at the moment. But this suit is expressly not maintained. Because Paritosh Maiti case, after reading section 258 of the Chota Nagpur Tenancy Act, full bench has said very clearly that only a suit for declaration of right title interest challenging the section 87 order is not required to be heard. I'm sorry. It says that despite the bar of 258, a civil suit for declaration of right title interest is maintainable. So in view of that full bench judgment, a simple suit for partition cannot be held to be maintainable lordship without challenging that legal character and the consequence of a judgment, because it says that in fact we are when filing against the section 87 second appeal, when we are coming before this honorable court, that this honorable court registry is asking us to propose substantial questions of law, treating it to be a decree in a way, because section 87 subsection 2 says so. It has to be a decree. So it has the effect of a decree, that section 87 order. So without challenging that order, ladyship, because that has an effect of not only the proof of, I'm not saying that it's a document of title. I'm only humbly submitting that is proof of title, attaches with it the legal verdict of a court, and not only that, the presumption of record of rights also attaches the presumption of exclusive right, title, interest and possession as regards the proof of it is concerned. So that proof of cannot be wished away by a litigant. My respectful submissions.
What was the exhibit of?
Exhibit B. I have a copy of it. If leadership may allow me, I can please show it to leadership. Exhibit B. Kindly see for a moment. For the trial court order judgment, may kindly be seen. At internal page 24. List of exhibits has been detailed. That is in the trial court judgment at page 12. That says very clearly at page 12, Exhibit B, certified copy of order dated 5/12/2009, passed in CNT Act 87, case number 90 of 2007.
Page number?
Page number 12 of
Appellate court.
trial court.
Where is the discussion?
Discussion, ladyship is
Appellate court.
appellate court. Appellate court is at para 17. Peruse the documents. Exhibit 10 is photocopy of record of right prepared during
That is
condition.
exhibit 10. We are talking about exhibit
Yes,
B, no?
yes. As far as the exhibit B is concerned, we have actually, that is consideration part is at next page, page 22. Page 22. On perusal of exhibit B and exhibit 10, I find that the suit property was recorded in the name of Bondhu Kumar and others. I have already discussed. Thereafter, it does not discuss the legal effect of the entire document, exhibit B. It only mention it for the, as a formal part only. Otherwise, the intrinsic value of that document, what does it say? It's a legal verdict. That has not been discussed. So how that?
You've got exhibit B?
Yes, please.
Please.
In fact, if your ladyship sees this exhibit B, there are about 3 or 4 dozen other plots also governing the rights of the recorded tenant, and that those plots are also record of rights have been corrected, and my name has been entered. In the first page itself, there is a lot of there are 2 suit plots also mentioned in exhibit B, in the second para itself. My substantial question of law, which I have proposed, kindly see C in the memorandum of opinion. Whether in absence of any declaration, because there are decisions in leadership that even in an administrative order, which affects the rights of a party, even if it is void, it has to get rid of that legal effect of that order. Because no order on its head can be said to be without jurisdiction. Even if it says that it is not binding against that party, he was not made a party, and even then he has to attack, impugn, and get the legal effect of that order. By a court of competent to declare such decree and get a declaration of such character in his name. Otherwise, because the pure simple suit of partition was not taken. May I just read from the memo of the
What were the issues framed by the trial court?
trial. Because it goes to the root of the matter also as regards the jurisdiction.
What are the issues framed by the trial court?
Yes. At paragraph 6 at page 10. Whether the suit as framed is maintainable, whether the suit is barred by the provisions of specific relief act, whether the plaintiff has got validity of title and unity of possession with respect to the lands in suit, proposed subject matter of partition, whether the plaintiffs are entitled to half share, whether the original plaintiff Amoli Kumari had the locus standi to file the present suit, whether Bondhu died leaving behind his daughter, heir and successor and not had any legal heir or successor, then the original plaintiff Amoli Kumari had any right to file the present suit, whether the suit land is available for partition at present or has been already in possession of BCCL on which it is operating mining operation. and thereafter whether the plaintiffs are entitled to get any relief or reliefs or not. In fact,
The
Ladyship,
recorded rayek is Godhu Kumar.
Bharat Kumar.
And it was rectified in the name of Godhu Kumar.
It was rectified in the name of these applicants. That is, he was a power of attorney holder, the appellant before Ladyship. He was power of attorney holder along with other defendants, and at his
Godhu Kumar is the descendant
descent
of Bharat Kumar.
Bharat Kumar.
Godhu Kumar is the descendant of Bharat Kumar.
Bharat Kumar.
Okay? And the plaintiff is the
Claims to be the granddaughter of Godhu Kumar, which she is not, as per that section 87 order, because that
it does not say that she is not the
no, it
granddaughter.
does not say that,
Then-
but it has a legal consequence of that. It has a legal effect of that. My respectful submission.
The genealogy will be decided by that order.
But I'm not saying that genealogy will be decided. What I'm saying is your simple suit for partition would not be maintained. He had to claim a legal declaration as to the legal character that she is despite that order which was brought before her. And she was supposed to seek a declaration
That she was the
that this order does not bind her. That this order does not bind her.
she is a party to that.
She is not a party to that. But Ladyship, I kindly appreciate if there is a legal order concerning the subject matter which puts a cloud upon a title, then she just cannot file a suit which is in the frame.
Heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment dated 19/8/2020 within bracket decree signed on 28/8/2020 passed by learned district judge 1 Dhanbad in civil appeal number 44 of 2019, whereby the learned first appellate court has dismissed the appeal and confirmed the judgment dated 31/2019 within bracket decree dated 12/2019 bracket close passed by learned civil judge within bracket senior division first Dhanbad in original within bracket partition bracket close suit slash title within bracket partition bracket close suit number 257 of 2011, whereby the trial court has decreed the suit the appellant is the son of Gaur Kumar,
Gaur Kumar, defendant.
who was defendant number 2 in the suit. The learned counsel submits that though both the courts have given concurrent findings, but a substantial question of law arises in this case, inasmuch as a suit was filed before the Revenue Authority under Section 87 of Chotanagpur Tenancy Act, seeking rectification of record of rights, which was allowed in favor of Gaur Kumar.
In favor of this Jaidev Kumar and the other heirs of Gaur Kumar.
In favor of
This Jaidev Kumar appellant before leadership, he was the power of attorney holder for rest of the heirs. He had filed a case for himself and for others as also. For
in
himself,
favor of
the heirs of
the heirs of Gaur Kumar.
Gaur.
The learned counsel submits that the legal effect of such suit, though decided by the revenue court, has not been properly considered by the court. The learned counsel submits that the plaintiff was that the suit itself was not maintainable.
Yes, simple
As-
partition.
The simple suit of partition was not maintainable in view of the order passed under Section 87 of the Chotanagpur Tenancy Act. During the course of hearing and upon the query by this court, the learned counsel for the appellant has submitted that the plaintiff was not a party in the suit filed under Section 87 of Chotanagpur Tenancy Act. After hearing the learned counsel for the appellant. This court finds that the partition suit was filed and admittedly the property involved in this case is recorded in the name of Bharat Kumar.
Yes, I'm just checking.
In the name of Bharat Kumar.
It was recorded in the name of originally in cadastral survey belonged to Bharat Kumar.
Belonging to Bharat Kumar. And
he died leaving behind his three sons, namely Bondhu, Sahib and Sutlal before cadastral survey. So these three persons must have been entered. Bondhu, Sutlal
and he died leaving behind his three sons, Bondhu Kumar, Sarveram Kumar and Sutlal Kumar. And the plaintiff was the granddaughter of Bondhu Kumar through Harku Kumar. It was the case of the plaintiff with respect to Schedule A of the land. The same was allotted to Bondhu Kumar exclusively, and some plot of the land remained joint and each married, which were not partitioned. It was further case of the plaintiff that Bondhu Kumar died leaving behind his only son, Harku Kumar, and one daughter, Radhi Kumare. According to the plaintiff, one daughter, Radhi Kumarin, and wife of late Manju Kumar. According to the plaintiff, Harku Kumar also died leaving behind his only heir and daughter, Amoti Kumari, Radha Kumari. Amodi Kumari, Radhi Kumari died leaving behind her four sons, namely Bhola Kumar, Kamal Kumar, Gaur Kumar, and Bablu Kumar, who were dependent number 1, 2, and 3. And Kamal Kumar, who died leaving behind his wife, Mangulini Kumharin, the dependent number 4. And only daughter and heir, namely Pada Kumarin, who was dependent number 5. According to the plaintiff, the defendant first party were the joint owner of Schedule A land, having half and half share. The genealogy given by the plaintiff has been mentioned in the judgment passed by the learned trial court. It was asserted by the plaintiff that they are governed by the Abhava school of Hindu law. It was further case of the plaintiff that defendants 6 and 7 required property in a portion of the property of Schedule A land for the purposes of carrying mining operation. And defendant number 8, son of Gaur Kumar, defendant number 2. It was asserted that the defendant number 6 and 7, in collusion with the officials and on the strength of power of attorney, according to the plaintiff, they have half share in the plot number 420 and 389. And also half consideration amount for sale of the two plots in favor of the number 6 and 7 by taking part in the negotiation. It was also asserted that the defendant number 8 managed to get his name recorded in the revision survey settlement operation by filing case number 90 of 2007 under section 87 of the Jharkhand Tenancy Act behind the back in the knowledge of the plaintiff. It was asserted that although the defendant first party were living separately in messing business and worship were their properties were never partitioned. And it was also asserted that the order passed under section 87 of CNT Act is void and illegal. And defendant number 6 and 7 had no right to purchase the plot number 420 and 389 entirely from defendant first party. The defendant number 1 to 5 and 8 filed a written statement. I think you were defendant number 8, perhaps. Jaidev Kumar.
Jaidev. 1 5
Son of God Kumar is party, and you are not Jaidev Kumar. You are who are you? Suni. Oh, Jaidev. Defendant number.
Jaidev. That
The defendant number 1, 5, and 1 to 5 and 8 had filed a written statement.
leadership in their plain.
Just a moment, please hold on. Had filed a written statement opposing the relief and also asserting that Gaur Kumar had no son. Gonu Kumar had no son, and he died leaving behind his daughter Ravini Kumari as his sole legal heir and successor. So the plaintiff had falsely inserted the name of Harku Kumar as son of Gonu Kumar. It was asserted that the suit land originally belonged to the recorded tenant, namely Godhu Kumar and Sahib Ram Kumar. But there was a partition between Godhu and Sahib Ram, in which the land of plot of Khata number 11, including plot number 213, 389 and 420, Schedule A was allocated to Godhu Kumar. Who remained in possession. And after his death, his daughter Radhi Kumari became the sole owner of the property, who died leaving behind 4 sons, Bhola Kumar, Kamal Kumar, Gaur Kumar and Bablu Kumar. And accordingly, each of the 4 sons inherited 1/4 share in Schedule A on the death of Kamal Kumar. It was asserted that Schedule A land was jointly owned and possessed by defendant number 1 to 5, and no other person had any right, title and interest over the same property. The defendant number 6 and 7 have also filed a separate written statement. The other defendants have also filed separate statement contesting the suit. The following issues were framed by the learned trial court. The learned trial court, after considering the materials, have recorded a finding that Amodi Kumarin was a descendant of Amodi Kumarin, the plaintiff, was a descendant of Bolu Kumar, who was the recorded player. The further findings have been recorded in paragraph 15 as follows. The court also considered the gift deed dated 10/9/1949 The court thereafter recorded that the defendant first party, that is defendant number 1 to 5 and 8, were contesting the case mainly on the basis of exhibit B, C and D, and recorded that the orders were passed on the genealogy issued by Circle Officer Jharia, that is exhibit D, on 26/4/2010, but the genealogy certificate was subsequently cancelled by the Anchal Adhikari by memo number 692 dated 29/12/2016. The court also recorded that exhibit 8 and 9 the court also considered exhibit 9, from which is transpired that the deputy gave direction to initiate proceeding against the employee who was responsible for issuing false genealogical certificate. And the said document was also sent to the defendant first party, but the defendant first party had not informed the court. The court observed that any order of taken on the basis of forged and fabricated document itself is illegal and void. The court then held that there was nothing to show that the suit property was exclusively falling in the share of the defendant first party in any partition or in any family arrangement. Paragraph 4, Roman 5 and Roman 6 of the appellate court judgment is this court is on the learned appellate court has also given concurrent findings. This court is of the view that the law is well settled that the argument of the applicant that order passed under section 87 of Chotanagpur Tenancy Act was binding on the plaintiff is especially misconceived in as much as the appellant, the plaintiff was admittedly not a party in the same proceeding. Otherwise, also in view of the judgment passed by the Honorable Supreme High Court in the case of Ayush Mehta, the suit was not barred. Consequently, the argument advanced by the learned counsel for the appellant that the suit itself was barred is not convincing. No substantial question of law arises according to this appeal is here dismissed.
In addition, my appearance will be recorded. I am appealing for respondent number 9 and 10 PCC.
You give your appeal, please.
Item 30, second bill 57 of 921.
Appellant. Who is for the appellant?
This is defendant second appeal. Where composite suit was filed, two leaves were paid by the plaintiff for partition of half share and for cancellation of the sale deed of the year 1954, registered sale deed of the year 1957.
Where is the trial court decree?
Yes, trial court decreed the suit.
Where is the trial court decree?
Sorry, madam.
Where is the trial court decree? You must have filed it.
Yes. Trial court decree is not there, not appellate court decree is there.
Why you to file trial court decree along with this?
It should have been filed. But I have a copy, a certified copy of the decree.
So, half share of scheduled B property and for declaration that the sale deed is fraudulent.
Yes.
When did you file the suit? 2013.
Fraudulent legal 2013. So trial court said that since in 2012, one of the plaintiff went to circle officer for payment of rent and issuance of rent receipt. In after lapse of about 72 years, plaintiffs went to circle officer for issuance of rent receipt and then got knowledge of sale deed of the year 1957. So this suit is not barred by limitation. The trial court finding ballot has been affirmed with respect to the limitation also by the appellate court. Although appellate court has taken note of it, one decision of the Honorable Apex Court, which has been settled that if in such a case of long delay and by clever drafting, the plaintiff try to bring the suit within period of limitation of 3 years. suit will be barred. And the first appellate court has also affirmed the finding of the point of limitation. Now, so far as my partition is concerned,
So on the point of limitation, it was decided in favor of the plaintiff by both the courts.
by both.
So what else? Let's say it was declared to be null and void.
No, yes, declared nothing. So now, my lord, my first submission is not, and so far as second issue regarding partition, the plaintiff's plea was contested on the ground that there was a previous partition, there was earlier family arrangement and memorandum of partition was prepared. That has also been that has been disbelieved on the ground that first it is not registered and second that this was not equitable, this was not legal. Both the courts
It
had
was not by meets and bounds.
by mid-set not legal because they have given finding that one of the possessor has not given sale.
So there is nothing.
No, well, there is something. Can you take the trial court judgment?
You just tell me what is your substantial. Lost in both the courts?
Limitation.
Limited.
Limitation, my lord.
Let us see what is the finding of the learned trial court on the
Yes,
point of
yes,
limitation.
yes.
Who is in possession?
Will be because that is their case in the year. Why I am telling my lord? Because case of plaintiff is necessary to see, my lord. So what is plaintiff's case? Plaintiff is saying just only two lines will be received, my lord. The record of right has been prepared in the year 1950. After 1950, Jamabandi has been created. They say that can you take internal page 5 of trial court, appellate court section.
You are on the point of limitation. No,
No,
paragraph 10.
I am on the point of limitation. First, I am raising point of limitation. But I am just taking the first pleading of the plaintiff in a nutshell, only two lines. Only two lines. Internal page 5 of the first appellate court.
Yes.
The second line. The further case of the plaintiffs are that the plaintiff number 1, Sohrai Kumrai on 26/7/2012,
Trial court, page number 5.
in the first appellate court. Because trial court has not given the pleading of the parties. It is on there. It is also in page number 5. Trial court. If my lord is taking trial court,
At trial court.
trial. Very
Page
good.
number 5.
Yes.
Yes.
Now we are
Page 5.
page 4. Their case will be from later on. Second, last one. Later on, due to increase in strength of family, they separated in ways and business, but started cultivating the land as per choice and convenience, and there was no partition by weeks and months. In the following paragraphs, plaintiff have given detail of genealogy and described about the former defendant. It is further assertion of plaintiff is that on 26/7/2012, the plaintiff number 1 went to Halka Karamchari to pay rent. This is important. But he refused to accept and told that 6.63 acres land had been deducted. So they tried to make out a case that for a continuous period of 60 years they did not pay rent. They went to make payment of rent and then got knowledge. Now that is their own case, my lord, that we are joint parties are living jointly, only for convenience they are living separately. So, well, now can we see the findings? And point of limitation has been framed under paragraph 5, issue number 4, and issue number 8. Now, my finding regarding the safety is there in paragraph 10. Now I come to the point and legality of genuineness of the alleged registered salary dated 10/9/1957. At first, I would like to say that when the title did not pass to Jhamman Kumar and later on Chundal Kumar, how he entitled to exclude salary, as I already discussed while deciding issue numbers such as such, that exclusive partition in favor of Jhamman Kumar. This is a wrong error on the record, Lord. Exclusive partition in favor of Jhamman Kumar was not done, then obviously the title does not pass to Chundal Kumar. Exhibit 1 shows that pending name as Masuma, meaning thereby Nemia Kumari, Moni Kumari, Sitwa Kumari, were widow at the time of the execution of the sale. It is also the pleading of the defendant in para number 21 of the written statement that Chundal Kumar sold the property to the aforesaid lady who was widow. But the story is different as stated by witness defendant now defendants. DW4 Ramanand Singh is very important witness of the defendant to prove the alleged memorandum of partition stated in para 22 of cross examination that at the time of execution of the son of Chundal Kumar was alive. It is also evident from exhibit B series rent receipts in the name of rent there has been mentioned as payer has been mentioned as Gotan Kumar. In exhibit B/6 name of rent payer has been mentioned as Anu Kumar. These Gotan Kumar and Anu Kumar are sons of Chundal Kumar. The aforesaid rent receipts are of the year 1964, 79, 83, 86, meaning thereby that sons of Chundal Kumar were alive at least up to 1996. Then how their wife becomes widow in the year 1957, meaning thereby by the defendants are telling lie, the pleadings of defendants are not supported with oral and documentary evidence. This is the finding. Thereafter, my lord, kindly comes to paragraph 11, my lord, number 1 to 4.
वो क्या बोलते हैं?
Now,
You just come to the substantial question of law. वैसे तो reading करते ही रहेंगे. There is no end
नहीं
to it.
उसके कारण नहीं कर
You come to the substantial question of law. You just say how the point of limitation has been wrongly decided.
my submission that in para 10 they have discussed the registered salary, and in para 11 by only showing that can you see fourth and para 11 thereafter para 11, because I was telling my case which is what is a case against me by the Sunday trial. Now kindly in para 11 the trial court has said that suit is not barred by limitation so far as the relief for cancellation of sale deed is concerned. Paragraph 11 of the trial. Why it is so? Because the plaintiff made the date, last third line, paragraph. Plaintiff made the date 6/11/2012 and 12/9/2012 as date of cause of action. So date of cause of action cannot be relevant from the plaintiff their own.
Date of knowledge.
Yes.
So date of knowledge, it's okay. How does this word make a difference?
This would make a difference, my lord, because they have made a case that they went to make payment of rent.
That's right.
They are saying, my lord, that we are the joint. Now, my lord, after lapse of 62 years, they went to make payment of rent. Now, 62 years, and SEDI was registered in the year 1957. there is not a single evidence, my lord, that they have comes to this particularly on 2012 they came to know about this registered sale. This is a registered deed of sale. Registered deed of sale, it is a notice to all concerned. Now, this finding has been affirmed by the learned first appellate court. Can you take note of it, my lord? Paragraph of the first appellate court, my lord. Paragraph 19.
Yes, we do.
So there simply, my lord, the learned first appellate court has also not disclosed that what is the evidence, how they came to know this is a registered sale deed, this is a public document, how they came to know there is no finding. Although limitation is a point of fact, limitation is a point of fact, I do accept. But at least Article 59 they have to be.
Second appeal number 57 of the.
So far as memorandum of partition which was produced, the both the court has said memorandum of partition, since it was a document of register partition, so it requires mandatory registration. Law says otherwise.
Law says that if it is a memorandum, it does not. If
Require.
a document itself is partitioning
Yes.
the property, then.
Yes, but partition was not being made. There were three persons. There is a finding of the both the courts.
Even if there is a memorandum of partition, if the parties are not separated and there is no partition by mix and bound, then also.
No, they
There are
were.
two things. There has to be a partition and partition has to be by mix and bound. Both the conditions is required to be satisfied.
Yes,
For
yes.
a valid partition.
Yes, for a valid partition.
So where there is no partition.
No, now the plaintiff has not come with a case that there was a family arrangement. Plaintiff has not stated this. Can you take me this point?
Plaintiff has not stated.
Yes. Defendant has come.
Not in the second appeal. Not in the second.
एक खाली जजमेंट लिखा दीजिएगा खाली डिसमिस क्योंकि इस पे फाइंडिंग है इस पॉइंट पे कि तीनों का शेयर है 1/3 तो इट कैन नॉट बी अ पार्टीशन वेदर इट वाज अ मेमोरेंडम ऑफ पार्टीशन
Para?
45 all earlier decisions has been discussed and the honorable court has said that if a new right has not been created, so it does not require mandatory registration. Because finding is that no share was allotted. This was no case of the parties.
Second appeal number 57 of 2021. This appeal has been filed against the judgment and decree dated 26 to 2021 with the Latin signed on 9 2021. That was passed as a district judge Roman 6 chapter dismissing civil appeal number 7 of 2019 and confirming the judgment and decree dated 31 March 2019 and that will decree signed on 14 to 2019. passed by the legislature and the legislative division, that is Romanji Jatra, in original suit number 9 of 2013. The learned counsel for the appellant has submitted that the learned court has wrongly disbelieved the previous petition and misconstrued Exhibit A, that is the memorandum of partition dated 11 to 1954. He has referred to the judgment passed by the Honorable Supreme Court in bracket 2022, bracket 367, paragraph 45. To submit that when the document itself is not creating any right on the immovable property, the same does not require registration. Correct?
Madam.
Para 45 of the procedure judgment is quoted as that. Further, the learned counsel has raised the second point that the SAD number 1124 dated 10/9/1957 was also challenged to be a fraudulent, illegal and void document. But the SAD having been challenged in the year 2013, its challenge was barred by limitation. He submits that the point of limitation has also not been properly considered by the court. The learned counsel has further submitted that the sale deed is a public document and therefore it could not be said that the challenge, therefore the challenge to the sale deed was barred by limitation. After hearing the learned counsel for the appellant, this court finds that the suit was filed for partition of half share of Schedule B property and also for an declaration that SAD number 1124 dated 10/9/1957 was fraudulent, illegal and void document. It was the case of the plaintiff that Sainath Kumar, Sobran Kumar and Chula Kumar were full brothers and had acquired 13.36 acres of land. And they died before service settlement. In the record of rights, the three recorded tenants jointly had equal share, namely Jharkhand Kumar, Durga Kumar and Jharkhand Kumar. In the record of rights, there are three recorded tenants, namely Jharkhand Kumar, Durga Kumar and Jharkhand Kumar. Amongst them, Jharkhand Kumar died issueless in 1956. In joint case with Durga Kumar and Jharkhand Kumar, the genealogy of the parties have been given in Schedule A of the plate. It was their further case that when Jharkhand Kumar died issueless, his last rites was jointly performed by Durga Kumar and Jharkhand Kumar, and share of Jharkhand Kumar devolved upon the surviving brothers. Jharkhand Kumar died in the year 1960. They had a house in which they were jointly residing. Chulan Kumar died in the year 1960, leaving behind his 3 sons. And Bhutva Kumar died in the year 1962, leaving behind 1 son. And they jointly used to cultivate the land. Due to increase in strength of family, they separated in messing business, but as per their choice and convenience, but there has been no partition by means of law. It was asserted that on 26/7/2012, the plaintiff number 1 went to Halka Karmachari to pay rent, but he refused to accept and told that 6.63 acres of land had been deducted, and the plaintiff was advised to raise the matter before the Anchal Adhikari. And when the plaintiff raised the matter before the Anchal Adhikari, a miscellaneous case was opened in which the opposite party appeared and presented SAIDI number 1124 dated 10/9/1957. And then the plaintiff came to know about the fraudulent act only on 21/8/2012. According to the plaintiff, Jharkhand Kumar died issueless and his share devolved upon both Chulan and Bhutva Kumar. And Chulan Kumar had no right to transfer the land. The application of the plaintiff was rejected by the circle officer by order dated 6/11/2012. And thereafter they obtained the certified copy of the sale deed, and then cause of action arose to file the suit. The defendant number 1 to 19 filed written statement challenging the suit on the ground of limitation and denying the cause of action. They denied that there was no unity of title and possession between the parties. The defendants admitted the entries made in the record of right, but denied the joint possession. It was admitted that Jharkhand Kumar died issueless, but denied that he died in jointness with Bhutva Kumar and Chulan Kumar. It was also denied that after death of Jharkhand Kumar, his share devolved upon Bhutva Kumar and Chulan Kumar. It was denied that Bhutva, Jharkhand and Chulan were full brothers. It was asserted that Thanu, Manu and Bodhi Kumar died in 1952-53 and they predeceased their father. And Jharkhand Kumar was alone at the last time of his life, and he was looked after by Chulan Kumar. And when Jharkhand Kumar died, his last rites was performed by Chulan Kumar. It was also asserted that in between Jharkhand Kumar, Chulan Kumar on one side and Bhutva Kumar on the other, the property was divided by way of family arrangement dated 11/4/1954. However, Bhutva Kumar refused to take the share of Jharkhand Kumar. And in the family arrangement, two-third share allotted to Jharkhand Kumar and Chulan Kumar, and 1/3 property was allotted to Bhutva Kumar. And family arrangement was reduced in writing on 11/5/1954. Accordingly, the share of Jharkhand Kumar was amalgamated with the share of Chulan Kumar. It was further case of the defendants that Chulan Kumar was in need of money, and consequently he sold the property to the extent of 8.84 acres to Mosamad Nimia Kumarin, Mosamad Mohni Kumarin and Mosamad Sitka Kumarin by SAIDI number 1124 dated 10/9/1957. And they came in physical possession of the property and applied for mutation. It was allowed and they were paying rent to the government. it was their case that there was complete destruction of vessel property after 11/2/1954, and the plaintiffs had no right, title and interest over the suit property, and that the defendants had every knowledge about the salient number 1124 dated 10/9/1957. However, they admitted the order passed by the circle officer dated 6/11/2012. Both the parties led oral and documentary evidences, and following issues were framed by the London court. The issue number 5 to 8 was considered by the court together, and the main issue was as to whether there was a partition, family partition as alleged by the defendant dated 11/2/1954, allegedly reduced in writing on 11/5/1994, was a legal and valid document or not, and whether there was any partition by means and bond, any previous partition by means and bond. The learned trial court considered the oral evidences and found that there was material contradictions in the oral evidences with respect to the memorandum of partition. And the plaintiff and the defendant also, though asserted that there was partition by measurement through a mean, but even this aspect was not supported by the evidence, by the oral evidences adduced by the defendants. The court recorded that the plea of partition was not supported by the evidence, and ultimately recorded that the court was not convinced that thereafter the court considered as to whether the oral evidence considered the oral evidence vis-a-vis the documentary evidence. The court recorded that the memorandum of partition is Exhibit A. If the defendant was relying upon previous partition, they were also required to prove that it was acted upon. And also as to whether the memorandum of partition was required to be registered or not. The learned court ultimately recorded a finding in paragraph 7 that there was conflicting evidences on record, and the document did not show that the property was partitioned by means and bounds. Thereafter, the court considered as to whether the Exhibit A was required to be registered or not. The court recorded that Exhibit A was not a legal document and not binding upon the plaintiff, and held that it was a fabricated document. Thereafter, the court considered as to whether there was unity of title and unity of possession between the parties. The court recorded that the document relating to partition has been declared fabricated, and there was no evidence on record to show that the alleged partition was acted upon. The rent receipt, sale deed was not a proof of partition. The rent receipt and the sale deed was not a proof of partition. And ultimately, the court held that the plaintiff was entitled for partition. Further, the court also considered the legality and genuineness of the registered sale deed number 1124 dated 10/9/1957. In paragraph 10 as under, and declared the document as illegal, null and void. The point of limitation was also considered thereafter under issue number 1 to 4. And the court considered that the plaintiff came to know that the plaintiff made the date 6/11/12/12/9/12 as the date of cause of action. And on 6/11/2012, the Anjaladhikari had refused the prayer of the plaintiff. The court ultimately held that the suit was not barred by limitation. The first appellate court also considered the materials on record and considered the details with regard to the point of limitation. And recorded the finding in paragraph 18 and 19 as follows. This court finds that the learned court has considered every aspect of the matter and has disbelieved the story of previous partition. And so far as the limitation is concerned, the court has considered that the suit was filed within 3 years from the date of knowledge. And the defendant had not brought any knowledge, any material on record to show that the plaintiff had any knowledge about the sale deed dated 10/9/1957. This court finds that both the courts have given confident findings not only in connection with the point of limitation but also on the point of previous partition. And there are confident findings discussing every materials on record, and therefore there is no substantial question of law involved. This, so far as the judgment reported in bracket 2022 bracket close 3 SCC is concerned, the same does not apply to the facts and circumstances of this case, inasmuch as the defendants had failed to prove that there was previous partition by mixer bound, and there are contradictory evidences on record as discussed by both the courts. Discussed. Orders to be sent.
From Supplementary list case item 72, second appeal 212 of 2022.
There is no substantial question.
Item 73, second appeal 173 of 2025.
I have raised a substantial question of law on the basis of the judgment which you have cited.
My submission is also admitted that some error had been.
आप सुने हम क्या बोले? आप सुने हम क्या बोले बताइए? I have not said that. I have said that there is a substantial question of law. I have admitted the case by framing a substantial question of कुछ भी बोलते नोटिस का कंप्लाइंस कर लेंगे जजमेंट आज आप लोग फाउंडेशन बिल्डिंग है आपका सारा जो आप पॉइंट रेज किए थे उस सब का फाउंडेशन बिल्डिंग आपके है रिकॉर्ड इसीलिए चलिए देखते हैं क्या होता है अभी कोई नहीं अभी तो नोटिस कर
because the
अभी कुछ नहीं होगा
money went to
अभी कुछ नहीं अभी आप नेक्स्ट डे
From supplementary list for the bit effect item 14, first appeal 15004 of 2025.
ठीक है
This
जी
is a limitation.
हाँ लिमिटेशन बताइए
Seeking annulation of 524 days in filing the present appeal.
where is the respondent
The reason is
where is the respondent आपका डिले काफी है इसमें
notices were served by my lord's order.
आपका कोर्ट फीस नहीं आया है आपका लिमिटेशन अब पहले का नोट करो बिना कोर्ट फीस के यस कोर्ट फीस
Court fee, that report was not there. It was only the pointed out by the passing.
Item 14 है supplementary list का
So, daily-
order with effect
daily.
नहीं सुनता है
हम भी कंफ्यूज हो गए कहाँ से कहाँ हाँ बोलिए
इसमें दो आई है अभी एक है एग्जेम्पशन फॉर्म फाइलिंग सर्टिफाइड
बाकी केस में तो नहीं फाइल किए बाकी केस में एग्जेम्पशन फाइल किए सर्टिफाइड
हाँ
और कोर्ट फीस
तो फीस के लिए रेडी हो गया है एक में तो हम फाइल कर चुके हैं बाकी में भी नहीं।
रेडी हो रहा है तो क्या करें हम आपके हाथ में है उसमें ऑर्डर पास कर दें
हम ये नहीं कर रहे हैं
तो
बस आप उसके लिए थोड़ा सा टाइम लेंगे
क्या चीज का हम टाइम आपको देंगे आप इस तरह से इस तरह
नहीं ऐसा नहीं है हम इतना लगे हुए इतना ये फाइल हुआ सब
बहुत बड़ा चुप्पा कर रहे हैं अपने लिटिगेशन पर फीस नहीं देता है क्या लिटिगेंट आपको भी देता है आपके क्लब को भी देता है ऑफिस एक्सपेंसेस भी देता है तो इसी काम के लिए हम लोग इतना कर रहे हैं तो बहुत भार हो गया है तो नहीं हो रहा है तो किसी और को
नहीं
दीजिए।
ऐसा नहीं है
अमेरिका से एक आधे अपॉइंटमेंट
थोड़ा सा उसके लिए टाइम
प्रीएम्प्टिव ऑर्डर हम करते करते काट दिए
होगा
हम काट दिए लास्ट में क्योंकि जान रहे थे कि आपका लिटिगेंट जो है डिफेक्ट नहीं रिमूव करेगा उसके बाद आपका केस DT हो जाएगा
जो आपने दिया था वो हमने रिमूव कर दिया
उसके बाद फर्दर
जिस कृपा के लिए आपको क्या क्या दे आपको ये बताइए ऐसे नहीं करेंगे हाँ?
One small detail. In our matters, Lord, we have filed an ITX stay also. Because Lord, what is happening, Lord, I understand that Lord, both the sets can be taken up together and heard together.
आप नहीं रिमूव किए ना तुरंत स्टे कर दें
But they are proceeding, Lord, they are
you are preventing us from deciding the case if you are proceeding I will immediately stay
They are proceeding, Lord, I can show it from the order.
I will not आप एकदम स्टे कर देंगे तुरंत स्टे कर देंगे फर्स्ट अपील है एडमिट हो चुका है स्टे कर देंगे आपको डिसाइड तो करवाना नहीं है
कोर्ट भी के लिए नेक्स्ट
नहीं स्टे करके ना सब कुछ स्टे करके
स्टे
स्टे क्यों नहीं होगा भाई यू आर प्रिवेंटिंग दिस कोर्ट फ्रॉम डिसाइडिंग दीस केसेस by not taking appropriate steps at appropriate time
हमने ये अभी हमने सारे में आईए फाइल कर दिया
सारे में नहीं किया है ना एग्जेम्पशन फ्रॉम कोर्ट फीस सारे केस में नहीं किया, और जब तक आपका कोर्ट फीस नहीं डिसाइड होगा आपका किसी केस में हम ऑर्डर नहीं करेंगे। जब तक आपका कोर्ट फीस पेमेंट नहीं होगा हम किसी केस में कैसे ऑर्डर करेंगे बिना कोर्ट फीस के? और आप हमको बताइए, दे हैव आल्सो फाइल्ड द अपील, करेक्ट? You are challenging the quantum?
We are challenging quantum. We are challenging the enhancement, Lords. It was initially, the initial compensation was somewhere between 4,600 odd.
Okay.
Thereafter, it has been enhanced to around 11,000. So we are challenging that enhancement.
And how much is the court fees?
लगभग 15 लाख।
15 लाख तो सबका मिला के है ना? आपको एक
एक
यूनिट
केस
थोड़ी
में हम लोग दे दिए हैं।
क्या दे दिए?
लीडिंग केस है, उसमें डिफेक्ट रिमूव कर दिया, उसमें नंबर पड़ गया, रजिस्टर्ड हो गया, इस आज लिस्ट में भी।
तो क्या करें हम?
नेक्स्ट केस के लिए ठीक नेक्स्ट वीक रखा जाए।
आप बोलिए कि बाकी केस इसके साथ नहीं सुनना है, हम सुन के फाइनली डिसाइड कर देंगे, हमको क्या है? ऐसे आप स्टॉल नहीं कर सकते किसी को।
जहाँ तक कोर्ट फी की बात
नहीं, अभी तुरंत स्टे करेंगे आपको फर्दर। इनका जो एडमिटेड अमाउंट है यहाँ जमा करा दीजिए। एडमिटेड अमाउंट
4,000.
वो भी नहीं दिए होंगे ना पेमेंट?
That I will have to take.
एडमिटेड अमाउंट एग्जीक्यूटिंग कोर्ट में जमा करा दीजिए।
75
Even if you have not deposited, that can be deposited. I will file an affidavit also to that. That is not.
I'll pass a direction to that.
Yes, direction is that
Stay will be subject to deposit of the admitted amount.
the initial amount which was decided by the, before the executing.
Before the execution.
They may not withdraw till the
Why?
termination.
They are not, you are only challenging the quantum. Why will they not be?
They have also sought enhancement.
They are seeking and they are seeking more money.
Yes, sir.
आप कम करने के लिए आए क्या? देखिए कम करने के लिए नहीं आए।
कम करवाने के लिए
तो एडमिटेड अमाउंट तो आप देंगे ना आपको, आइडेंटिटी कोई डिस्प्यूट नहीं है।
initially the amount which was determined, that
Whatever amount has been determined, that should be paid. Enhancement और reduction पे हम लोग लड़ेंगे, फिर देखेंगे क्या करना है। आपको तो डिसाइड कराना ही है केस।
कम कराना है। नेक्स्ट इसी डेट को रखा जाए, इसी बुधवार को नेक्स्ट डेट को आप करना।
आप पेमेंट ले लीजिए वहां से, उसके बाद कोर्ट फीस जमा कर लीजिए। सिंपल।
कोर्ट का ऑर्डर पेमेंट नहीं जाएगा।
हाँ तो जो भी इनका एडमिटेड अमाउंट है वो जमा करेंगे ना,
हाँ,
उसके बाद उसी में से आप कोर्ट फीस यहाँ जमा करा देंगे।
जो पहले कोर्ट का
फिर आपका आईए जो है वो रिजेक्ट कर देंगे, एग्जेम्पशन फ्रॉम डिपॉजिट ऑफ कोर्ट फीस।
पहले आपको पैसा मिल जाए
2 + 2 4 होता है।
उसमें कुछ मिला ही नहीं। 4,000 रुपये लोग कोर्ट डिस्मिस किया। फाइंडिंग 15,000 रुपये है, 11,000 अलाउ है। फाइंडिंग एटलीस्ट 15,000 है, 11,000
आपका कोर्ट फीस उससे ज्यादा है क्या? कोर्ट फीस कितना है?
15-16 लाख।
लिमिटेशन में क्या बोलना है आपको बताइए।
लिमिटेशन में नंबर पड़ेगा तो
एक केस में जिसमें नंबर पड़ा, इसमें सिर्फ एक ही आई है ना, 1132 और भी आई है क्या?
एक ही FS 78
हाँ
Yes, what you have to say on the point of limitation? आपका भी तो डिले करना
there was a delay on our part because there was a delay of only 20 days. Filing 24 days because in filing the first appeal. For them because the delay is massive because it is more than a year because from what it seems. They have not in their application because for combination of delay they have not stated any cogent reason because we can file a reply to that effect, because for that was some sufficient time in the plus we file it out affidavit so that.
आपको भी कहाँ seriousness है? आपको लगता है delay नहीं control होगा first appeal में? Whether quantum is under challenge? Is there any likelihood?
I go down, but only to that part where the affidavit to that effect and blood like that, we may be permitted to file that.
तब हम stay नहीं करेंगे. आपको भी time चाहिए, इनको भी time चाहिए. आराम से रहिए, आप हम लोग को कैसे?
Now तो defects ही clear हुआ था, because that is why.
आप आइए पे रिप्लाई आपको जो करना है.
Admitted amount we have received is because the admitted amount is already deposited.
Already deposited.
Yes.
चलिए, admitted amount is already.
कलेक्टिव अवार्ड के बारे में बोल रहे हैं।
उसी का
उसी का ही तो वही तो admitted amount है. और कौन सा admitted? That is the admitted amount.
जो इनहांस हुआ है 11,000।
Enhanced amount थोड़ी डिपॉजिट कराने का ऑर्डर करना है. वो कैसे करते हैं?
वो तो अवार्ड में उसका अवार्डेड अमाउंट है उसको जमा कर दो। अवार्ड में जिसके मनी का अवार्ड है इसको इसके इतना कैसे कर सकते?
केस डिसाइड करवाने के बारे में सोचिए.
हम नेक्स्ट वीक बस एक सप्ताह ज़्यादा नहीं उसके बाद हम
कितना टाइम लगेगा?
Let's file the reply. We file it for the next day.
सब केस में टेंटेटिव वही है.
We file for the next day.
नेक्स्ट वेडनेसडे
सेम है टाइम तो 324 दिन का, बाकी समय पहला केस में 320 दिन.
FA number 78 of 2026. With IA number 1132 of 26. This petition has been filed for confirmation of delay in filing this application. Counsel for the respondent submits that if the matter is posted in the next week, a reply to the petition for confirmation of delay will be filed. Post on next Wednesday. ये वाला. और बाकी में तो कोई फीस ही नहीं हुआ अभी आपका. आइए फाइल हुआ एक में.
एक में हुआ
किसमें फाइल हुआ बताइए?
75.
पहला वाला
आइए नंबर
आइए नंबर 1190
ये कौन सा 1190? इसमें
Number 15004. आगे 119.
exemption. Exemption from filing certified copy.
सस्पेंशन ऑफ कोर्ट
Suspension of court fees. Condonation of delay है and suspension of court fees. Okay. IE number 1190 of 2026 has been filed seeking with a prayer to suspend the payment of court fees amounting to rupees 82,316 till the outcome of the present first appeal. The learned counsel for the appellant has referred to the judgment passed by this court in first appeal number 127 of 2006 with analogous cases and has submitted that under similar circumstances, the court has been pleased to observe that the deficit court fees shall be deducted first at the time of payment of compensation. The learned counsel submits that appropriate order be passed in this case also. जितना कोर्ट फीस है उतना आपका कॉम्पनसेशन है कि नहीं? कॉम्पनसेशन उससे ज्यादा है कि कम?
उससे ज़्यादा
एडमिटेड कॉम्पनसेशन उससे ज्यादा है कि कम?
डिसमिल।
4000 पे पर डेसिमल है मतलब 1 डेसिमल का 5300 रुपये है, 5300 रुपये फुट फीस।
हम आपसे ये पूछ रहे हैं, अगर आप केस हार जाते हैं और ये केस जीत जाते हैं, तो आपका जो कॉम्पनसेशन अमाउंट उससे कोर्ट फीस रिकवर होगा कि नहीं? यस,
Perhaps for that, because of calculation should be drawn by both of us.
इससे इधर कैलकुलेट किया हमको बोलना थोड़ा सा
एक डेसिमल का प्लॉट यहाँ पर 5300 रुपये कोटेशन 5400 रुपये दिए।
अवॉर्डेड अमाउंट तो काफी है इसमें, 57 lakhs है। Considering the fact that the awarded amount in the present case is 57 lakhs and odd, and the appellants claim to be poor villagers who have lost the land in the acquisition process. This court is inclined to grant similar relief as has been granted in the order passed in first appeal number 127 of 2006 dated
Yes.
13th of September 2013, and directs that the deficit court fees shall be deducted first at the time of payment of compensation. And consequently, the payment of court fees as directed by the office amounting to rupees 82,360 stands suspended. Let this order be communicated to the concerned court through fax. और बताइए ये और certified copy.
दूसरा सर्टिफाइड
IE number
1084
IE number 1084 of 2026. This petition has been filed seeking exemption from filing certified copy. The counsel for the appellant has submitted that arising out of common judgment, the certified copy has been filed in the connected case, that is first appeal number. किसमें फाइल की?
सारे में सब
भाई किसी में तो फर्स्ट अपील में
फाइलिंग
certified
नंबर सिर्फ फाइलिंग नंबर है
किसमें फाइल की?
फाइलिंग
बताइए
नंबर
ना।
15004
In filing number ये 15004 में सर्टिफाइड कॉपी कहाँ है?
सर्टिफाइड कॉपी 14997 जो अभी 78 हो गया इसमें नंबर पड़ गया।
इसमें नंबर पड़ा हुआ है
In
फर्स्ट अपील 78
in filing number 14997 of 2025, which has been numbered as first appeal number 78 of 2026. The learned counsel has submitted that so far as the award is concerned, the certified copy has been filed.
Yes.
Considering the submissions, the petition seeking exemption from filing certified copy of the imbued judgment is allowed. And subject to payment of the required authentication fees in connection with the imputed judgment within a period of 1 week from today. Great. इसका authentication fee आप सबका जमा कीजिए।
670 rupees by
670 rupees.
67 rupees, 67 pages.
The learned counsel for the
मेरा 10 केसेस है इस पर
76 है ये
67 pages.
67 पेजेस है।
10 rupees per
ऑथेंटिकेशन फी
page.
कितना है इसमें लिखा होगा ना।
10 rupees per page, Lord, it is 670.
This council further respondent has submitted that the authentication fee would be 670 rupees. ठीक है, ये हो गया। और आइए का फाइल कर दीजिए आप। The petition seeking coordination of delay is also on hold. The council for the respondent submits that prior to the next date of hearing, the reply to the limitation petition will be filed.
ये ऑथेंटिकेशन फी तो एक ही ना लगेगा।
एक ही आदमी का केस है।
नहीं, केस नहीं है, क्योंकि इस तरह का जो हम लोग यहाँ आए थे, एक ही फैमिली का केस है, एक ही
क्यों नहीं एक गांव का एक ही केस होना चाहिए? नहीं, ये सब नहीं, रिजेक्ट कर देंगे, रिजेक्ट कर दें। हर एक केस में आपको जमा करना पड़ेगा।
रिजेक्ट कराना नहीं है,
बस
सिंगल केस में एक में हुआ है।
नहीं इस तरह का
Along with our batch members, our batch of cases.
हाँ, नहीं इनका बैच ऑफ केसेस आपका रिकॉर्ड आ गया।
Yes, Mr. Records have come, Lord, we have verified. The next date, Lord, it may come along with our batch also, Lord, because we have also filed an idea for stay in the first.
28 to 126.
लिखिए बाकी केसेस में लिखिएगा। So far as other cases are concerned, the court fees has not been paid by the appellant so far, nor any petition has been filed seeking exemption from payment of court fees. The time of 1 week is granted to the appellant in each case to file the deficient court fees or to file an appropriate petition seeking exemption from payment of court fees. Post on 5th of February in the supplementary cost list. Preemptory order है, order preemptory है, नहीं फाइल करिएगा तो पक्का डिसमिस होगा।
7 कर दिया।
7th को कैसे आ सकते हैं?
ये नहीं
5th of February,
नहीं
एक हफ्ता से ऊपर देखिए ना, आज 28 है, 5 तारीख को आ जाइए।
एक को थोड़ा सा है,
कुछ नहीं होगा, 5th को आ जाइए।
नहीं
Our
सारे केसेस आएंगे 5 तारीख।
78 to 136, Lord, is our matter, Lord, that is under the hearing for hearing, Lord, that may also come up on this.
Records have been received.
Yes, because
वो जो उनका बैच है जो इनका हियरिंग में लगा हुआ है।
78 to 136.
The records have counsel for the appellant has submitted that the records have already been received. नहीं हुआ, आ
I
गया रिकॉर्ड आ
verified from the
गया,
office,
आ गया।
was called for only the lead case.
At the request of the counsel for the appellant, holds this case on the same day, that is 5th of February. The counsel for the appellant is directed to prepare
पाँच की जगह
short
5
synopsis of arguments and the judgments which he seeks to rely upon in support of his case. The respondents may also do the needful such that these cases arising out of land acquisition are decided at the next.
Like,
आज की जगह 9 या 10
इसको भी सप्लीमेंट्री लिस्ट में डालेंगे 5 तारीख।
और 9 या 10 को फिर
9 या 10 को क्या करेंगे?
फिक्स
ठीक है, 9 को कर देते हैं, लेकिन प्रेम्पटरी ऑर्डर है एक हफ्ता का, वो नहीं चेंज होता। 9 मंडे, ट्यूसडे को 10th को सप्लीमेंट्री लिस्ट में सारे केसेस। अब आप लोग तैयारी करिए, ठीक है ना? ओके, अच्छा वो जो बैच था वो तो डिस्पोजल हो गया होगा, जो ऑर्डर लगाए थे कि वो भी पेंडिंग, जो फर्स्ट अपील का लगाए थे दिखाई सर, वो जो आईए में जो ऑर्डर था ना, फर्स्ट अपील नंबर कौन सा था, वो डिस्पोजल हो चुका है, पूरा बैच है उसमें जिसमें एग्जेम्पशन था फ्रॉम फाइलिंग सर्टिफिकेट कोर्ट फीस वाला, हो गया डिस्पोजल,
Lord, one
उसको तो चेक करिए।
Lord, extension of the stay granted by.
तो सुबह 10:30 बजे कोई
So
मेंशन नहीं
mention हुआ है,
आप किए थे,
mention हुआ है।
अदर साइड आ गया,
Serial 10 Lord.
अदर साइड है, सीरियल 10 ब्रीच है,
Stay was
second appeal.
आप कौन?
सीरियल नंबर 21
दूसरा केस को छोड़ दीजिए, अभी 5 बजने वाला है, इनका स्टे एक्सटेंड, इनको ऑर्डर एक्सटेंड कर दीजिए। कब के लिए कर रहे? रिकॉर्ड आ गया?
हियरिंग के लिए है, इस पर बहस भी हो चुका है।
As the case could not be taken up for final hearing today, due to paucity of time, the counsel for the appellant has prayed for extension of interim order passed earlier, which is expiring today.
No.
Let the matter be posted on February 17. The interim order is extended till 17th of February from.
सीरियल नंबर 21
क्या है 20?
सीरियल नंबर 21 एक्सप्लोर लिमिटेशन पे चल रहा है, वहाँ एक्सक्लूशन चल रहा है, इसलिए इसको सप्लीमेंट्री में कोई भी बस टाइप कर रहा है।
सेकेंड अपील है।
फर्स्ट अपील इसमें स्टे भी हम आई फाइल किए हैं 187 डेज का।
एक ही और तो कुछ डिफेक्ट नहीं है ना?
नहीं, बस वही सारा डिफेक्ट सिर्फ लिमिटेशन था।
देखिए तो आइए नंबर कितना है? अगर एक भी डिफेक्ट और रहेगा ना तो ये ऑर्डर हमें सही नहीं। आइए नंबर सीरियल नंबर 21 का आइए देख लेंगे, ठीक है? रिस्पोंडेंट कौन है?
प्रीवियस केस का भी सीरियल नंबर नहीं पता चला।
हाँ?
शशांक शेखर
रिस्पोंडेंट कहाँ है? वो मतलब ऑलरेडी अपीयर हो चुके हैं।
अपीयर हो चुके हैं।
स्लो मत हो।
नहीं, वो उनको नोटिस नहीं हुआ,
नोटिस क्या
वो स्लो मोटर पे हुए हैं। अब उन्होंने काउंटर भी फाइल किया हुआ है इसमें।
लिमिटेशन पर
लिमिटेशन
कल कर दीजिए, tomorrow।
under item 28
अब क्या?
only I prefer tomorrow if possible।
इतना स्पीड नहीं है हमको, देखिए आप बोर्ड देख रहे हैं ना।
बहुत कंसेंट वाला डायरेक्ट और थर्ड
अभी कुछ नहीं, अभी
अच्छा, तीन को
देखिए इतना हमको कैपेसिटी नहीं है।
रिटायरमेंट
रिकॉर्ड पढ़ने में मेरा तबीयत खराब हो जाएगा।
हम समझ रहे हैं, खाली
हाँ,
रिटायरमेंट
छूटे हैं तो
मैटर नहीं,
पन्ना फट जाता है।
हमारा रिटायरमेंट नहीं मिल पा रहा इसी केस के वजह से, सरचार्ज केस, इसीलिए पिटिशनर 70
आएगा नेक्स्ट वीक का।
नेक्स्ट वीक
आप सोच नहीं सकते हैं, फाइल छूते हैं फट के हाथ में आ जाता है।
मैडम ये
हम सेलो टेप साथ में लेके